Right, so a bit about my background for those of you that don't know me. My name is Ross, and I'm a cybersecurity and privacy specialist, and I help particularly software companies grow their client base by helping with technology, trust, compliance, because often you don't see people taking much mind of privacy until such time as they lose a client or they can't sign a deal because there is a privacy issue or a compliance issue to GDPR or soon to be POPIA in South Africa. So we're going to go through some of the challenges that a software company might experience on some of the cybersecurity and privacy sides of things. So topics we're covering today is cybersecurity and tech PI insurance. We're covering data subject access requests. We're covering the difficulties of blanket risk assessments. I'm not sure if you guys have experienced this yet, but where you get everything but the kitchen sink thrown at you to answer when you take on a client. Development and data privacy impact assessments, DPIAs, and data de-identification and the risks thereof. Right, so let us jump into cyber and tech PI insurance. So we've heard the phrase cyber insurance, and what it entails is an insurance policy that covers you for a number of the risks that you might experience. Things like hacking, extortion, fines that may come from regulators, civil action, legal fees, things like that. So it's a really good thing to have, but it is not without its challenges. A few of the major challenges that we experience as software companies when it comes to cyber insurance is one, that it is out of your hands in many cases as to what data is being stored in your system. Many of these cyber policies work on a number of records that are under your control. So if you have 10,000 records under your control, they'll work your policy out on 1,600 Rand per record or 1,200 Rand per record. That's the cover you need, et cetera, et cetera. If you are sitting with software as a service or a hosted service of some kind, often you're not in control of what people are putting in the system, so you cannot put a number to the records that you have. Just on that as well, if we talk about records, often it is a person would be seen as a record. That does tend to change depending on the insurer, so check that. But it becomes very, very difficult to get insurance in this case. The next problem when it comes to a software company is that there are often record limits when it comes to taking out an insurance policy. So if you have, say, 50,000 records, that's fine. But when you start breaching the million mark, where you've got 1 million people's information potentially in your system, suddenly insurers kind of take a step back and say, no, well, we're not too sure we're going to insure you on this. So you have that challenge of a limit there as well. And with that limit comes exclusions from cover. And you will have it that certain insurers will exclude certain covers from you because of the nature of your business. It's quite interesting to see that you'll have cyber insurance where companies will cover any company with a turnover of up to 250 million, they'll cover them for insurance, unless you're a tech company. Then you're only covered if you've got a turnover of 25 million or less, otherwise we don't want to come near you. Now, that's not to say you cannot get insurance when you're above that, but it's more likely that you're going to go through the likes of a Lloyd's of London or someone with massive, massive risk appetite in order to get that cover. So there are risks of getting exclusion from cover, particularly from affordable options for exclusion from cover. You've also got at least two environments to worry about. So you are hosting an environment in AWS and you've got your internal environment with employee data. Those are two environments that you have to look out for. And you've got to meet these minimum requirements that the insurers need. And often that'll be different because your environments operate differently on either side. So a hosted environment may not have two-factor authentication, but your internal environment does. The exclusions will happen on your hosted environment, which is probably where you want them least. So it is very much a challenge there. Then closer to home in the company, you've got things like guest Wi-Fi. And this is where you have, it's sort of the court of public expectation, not opinion, where people want a guest Wi-Fi when they walk into your office. And this is a pet peeve of mine. I don't think if you don't have a training center in your office, there is no reason for you to have a guest Wi-Fi, in all honesty. People have their phones nowadays. Data is becoming more affordable. And a guest Wi-Fi just opens you up to so much risk. And a lot of times, if you've got a guest Wi-Fi, insurance will cut you right there. They will just say, no, we're not interested because you allowed guests on your network. And I can see why they would do that, because often when I go into a company, the first analysis I will do is I join the guest Wi-Fi and I do a network scan. And often I will return every database on every developer's machine, as well as all the testing databases for support, as well as everything on the servers. So I can see where they're coming from with this, and it really is unnecessary. If you do have to have a guest Wi-Fi, have it completely segregated, get an outside party to also come and check that the segregation is working. And then we mentioned with that financial cover, there's also stricter qualifying criteria for a software company when it comes to insurance. Often they will apply a whole lot more requirements that a client-facing website will need that you wouldn't normally need because of the nature of you having data that could be stored all over the show. Lastly, and this I mentioned in the last webinar that I did, is that there's a massive third-party attack risk when it comes to a software company. What guys are doing now, the hackers, is they are saying, you know, attacking a bank is very difficult because there's red team, blue team, there's budget to throw at security and all sorts of protections. There's PCI, there's all sorts in place. So why not go after their suppliers and try and get access there instead, because perhaps the supplier doesn't have the budget that the bank does. So the attack vector is moving over now to attack the software companies to try and get data there. And we've seen that in a number of breaches here in South Africa already. So now there is this dark horse called professional indemnity insurance, which is basically 3 policies in one. So it's your general liability, professional indemnity, and your cyber insurance, which sounds like a great thing, but in general, it won't cover third-party insurance. Now, when we talk about first-party and third-party in cyber insurance, we are talking about covering you as a company. So first-party, if you have a breach, what are your legal fees? What are your forensics fees? What are your PR fees? Things like that. The insurance will cover that. When we talk about third party, it's anything like reparations you have to give to users. So if we think of the Marriott breach that happened, where passport information was taken, Marriott had to go and buy identity protection for everyone whose data was stolen. And at $10 a head or whatever that was for 500,000 users for a year and a half, that's a really expensive endeavor. So you need to look at this third-party insurance and third-party cover, and do you need it? Often the answer is yes, but go look at your policy wording because it might not be there. So what TechPI does cover, though, is it covers breaches in terms of technical faults, bugs, errors in code, configuration errors, things like that on your servers, which is really nice for a hosted environment. The downside to this is if you are attacked by hackers and they breach you because of the code issue, your insurance might not cover you. So it is an absolute minefield for software companies here. So if someone hacks you, they take advantage of a tech fault, suddenly your insurance might not cover you. So you've got to make sure you're really watertight. And for that, I would say you need to have your vulnerability assessment done. You need to have penetration tests done. It works so well in your favor. The good thing about this TechPI insurance as well is that it covers you internally very well for cybersecurity. So if you are just dealing with internal data, employee data, client data, you're processing inside a company without a client-facing section, or public-facing section, should I say, you are covered really, really well for first-party and third-party under the cyber insurance part of the TechPI insurance. Right, I'm getting out of breath talking about all the challenges that we might have just with insurance. What are the recommendations that I can give you? And guys, like I said, please pop questions in the box if you do have them. Recommendations around cyber insurance is check your policy wording carefully. If you have got a policy in place already, please go and check the wording. Do you have first party? Do you have third party? What are the exclusions? Have you gone over the threshold of what your insurance is? Because you can get denied insurance very, very quickly. Next, ask for what the minimum requirements are for the insurer. This is if you've got a policy already as well. If you've slipped on one of the minimum requirements, or they've changed their minimum requirements and increased it, they come in and check and you don't have those in place, they can deny you cover. So you need to ask for these minimum requirements, do a gap analysis. Do you have everything in place? It's things like password resets. It's things like group policies. Make sure you've got those in place. And if you've got a gap analysis, identify your quick wins and then go and implement your quick wins. A lot of times these things will look like this massive laundry list of things that you've got to implement, but it's really quick to implement most of them. If you can't implement these, and this is where a lot of people walk away from cyber insurance, and I'm going to say don't, talk to the underwriters. Often if you have not met the minimum requirements, you can speak to the underwriters and they can do an exception for you in certain cases. I've had it where things like a VPN, their minimum requirements is that you must have two-factor authentication on a VPN, which in some instances is impractical to do. But if you've got a pre-shared key on a decent VPN, LTTP or something like that, that can qualify as a second factor. So it doesn't necessarily exclude you. So look at that kind of thing as you're going through. And this is the scary one, particularly for the folks in South Africa. I know we've got some folks from around the globe here. Get cover for at least 20 million Rand if you are getting cyber insurance. And that's quite a cringeworthy figure. And it's gone up now. It was 15 the last time I did this presentation. But our Rand dollar has changed rather dramatically. But you want cover for $1 million US, basically, if you are dealing with clients in the USA. Because a US legal issue can escalate to $1 million incredibly quickly. So third-party insurance, 20 million cover for South African Rand. Very, very important. The next that we're going to discuss is data subject access requests. This is not something we've necessarily seen a lot of in South Africa, but it comes in with the GDPR regulation in Europe. And if you have any European clients or you have any aspirations of dealing with Europe, you need to comply with GDPR, whether you're a South African company or not. So GDPR applies extraterritorially. We need to be aware of it. And one of the big things out of that is DSARs. Now, the big challenge in DSARs, and perhaps to take just a step back, your DSAR, data subject access request, is when you have an end user who decides to exercise their right to be forgotten or to have their data deleted. They need to submit a proposal to the data controller. The data controller then sees to it that that information is removed or stopped processing within 30 days. Now, that's easy to say up front, but to try and get through the challenges is a whole nother story. Most software companies fly by the seat of their pants. You're working in agile environments, you're working in high-paced environments, you're turning around software very, very quickly. So processes and maps of data and things like that aren't necessarily done on a regular basis or kept up to date and things like that. And one of the big things you need with your data going through your company is knowing what your processes are and knowing where you generate data. So a challenge is that we are flying by the seat of our pants and we need to actually take a moment to see where data is. The next thing that's a challenge with DSARs is that we have records for companies in shared databases, and this can be things like shared tenancy as well. Shared tenancy has a massive, massive effect on data privacy, and we'll get to that in the next slide. We also have these ticketing systems that we use for support, and please guys, if you're doing support tickets, don't take a ton of information. I've seen it at so many companies where filling in the support ticket takes longer than resolving the support issue. Try and keep it to as little information as possible. The less information you have in a company, the lower your risk is. So taking only the information that is required for a support ticket really helps you here, because support systems and having nice to have fields and nice to know fields about your clients is all great, but it adds to your data glut like you wouldn't believe. So try and avoid these ticketing systems that take every piece of information you possibly can. Next, we don't have DSAR policies. You want to have a policy and a procedure as to how you address these data subject access requests. The big challenge here is, like I mentioned, there's 30 days. And you have a reliance as a software company, you are likely the processor. You have a reliance on the controller telling you to do something with the data. So if you are business to business, you are likely going to be the processor. If you are business to consumer, you're likely to be the controller. Controllers have 30 days to respond. Business to business, you've got to wait for a controller to let you as the processor know that there has to be something done on data. That's still within that 30-day window. So if they wait 3 weeks to tell you, you need to go and delete this data, you have 1 week to comply, or otherwise they're in non-compliance and it's a sticky mess. So you want to have a policy and a process in place so that you can respond to it quickly. Similarly, the guys that are business to consumer, you want this in place too, so that you know where to go once someone requests it. If you've got 30 days to respond, best know how you're going to do it. Now, what are the nightmare materials here when it comes to data subject access requests? A big one is email correspondence. We don't realize how much information sits in our inbox, outbox, sent items, junk email even. You get all this information on a daily basis into your mailboxes, and what happens to it? It perhaps gets archived or something, but we don't often sit and clear our mailboxes, clear our mailboxes, clear our mailboxes. So you end up with a lot of personal information in there that you've got to be very, very careful of being there, and someone requests it to be removed and you don't. And then later there's a complaint that you didn't remove it. They come and see, and oh, there's still emails. Suddenly that's there. Your email mailboxes need to be treated like a database as well. And that brings me to the next even more difficult thing, and that's when you've got immutable archives on your emails. So if you are using a Mimecast, a Synac, a Semantic, or some other solution to archive all your emails into an immutable archive where people can't go and delete mails, you're suddenly faced with this challenge that someone requests information to delete, but your company policy says that you don't delete any mails. You've got this clash. So that becomes a challenge. Next one, backups. Backups are a huge challenge. It's really easy to clear live data of people or information or companies. It is really difficult to clear backup data, particularly in the case where you've got a shared tenancy system. So if you have a single backup set for, say, 15 databases of your clients, and one record has to be removed from one database, it's easy to do in live. But now what happens to your backup set that you've got going? You can't go in there, restore the whole backup set, remove one record, re-back that up, and it's a nightmare. So that becomes a massive, massive challenge. And that's where you're actually going to have a project that's long-term to try and resolve this, because backups, as simple as they are on the surface, they are absolute nightmare fuel when it comes to a data privacy solution. So what are my recommendations for you guys here? First, if you're doing future projects, try and avoid shared tenancy where you can, or at least have some sort of logical segregation that's easier to get to clear data out. If you have separate backups per client, it makes it easier to remove information out of a backup that only belongs to one client than suddenly a set that covers all your clients in one go. The smaller the chunks, the easier it is to manage with that. When you've got backups in place already, please consider putting in a plan to go and look at your previous backups and try and see how you can restructure it. Having a clear retention policy on your backups gives you the opportunity at the end of a retention to move on to a different platform or a different architecture or something like that. So consider some sort of project in the long term to start moving that way. We don't necessarily see DSARs in SA now, but they are going to come. If we look overseas, there are instances now where companies have had denial of service because they have been hit with so many DSARs from online communities for something that they've done. I think one of the big ones happened with Blizzard. They banned a gamer for comments on the Hong Kong protests, and then suddenly a whole group of gamers went and issued all these subject access requests, which the company had to honor, and they ended up having to hire teams to go and respond to all of these within 30 days. It's quite crazy. Next, when you've got archiving tools, use tools that have DSAR functionality built in. A lot of them do. So you want to have that additional functionality on there so that if you have an immutable archive, there is some sort of mechanism built in that you can go look at this. Ensure that retention periods are set and are minimal. One of the convenient ways, and it depends on your business model, but it's something I've seen where dealing with this problem that you've got to respond in 30 days is reducing the backup retention to under 30 days where it's possible. Then what happens is, yes, it may be shared tenancy, but you've got 30 days to respond and remove that information. Now, 28 days later, that backup set is rolled over and that information is no longer in the backup set. It sorts itself out without them having to go in, try and do restores, removals, things like that. So you can do some clever stuff with your retention periods, and you can also justify responses if you do have other retention periods set. So there are extensions that you can get to DSARs and things like that if you can come up with a valid reason. Now, something we do see is people saying a valid reason is that it's too technically difficult to do, and according to the letter of the law, you can use that. However, according to what the data regulators are saying, is that's a very weak excuse, and they will still come at you for proof on that. And if you use that and it turns out that it wouldn't be too much effort, they can actually hit you with additional fines, which you don't want. And then lastly, please, or second last at least, map your processes in the business. You want to see where data moves and where it's created, because then you can keep a track of where something moves. If a support ticket has come in and you've got to create an escalation in another system, that's a new data set that you've created. So if someone requests something to be removed, you need to go look there instead of forgetting that it's there. There are software packages in the world that you can use to do this. There are methodologies as well. You can use ISO's operating procedures, or you can use a method like Obashi. There are a whole lot of ways of doing this, but the point is you need to do it. Part of GDPR is you also have to have data flows mapped within the business. It's part of what you have to do. And in software companies, we rely on data. So please do that. And then the information that comes in, and this ties into POPIA principles, it ties into GDPR principles, African Union, it ties into Canadian principles. Limit the data that you're taking internally. The less data you take in, the lower your risk. So try and keep that limited, try and keep it clean, take the minimum that you require to do your job. Often we don't need all the information that we request, and we end up with this bloat of data that we can't actually manage in the end of the day. Moving DR, software as a service providers, how do you ensure that your details are removed post the retention period? So that's a very good question. You need to work on the processing agreement that you have with your DR as a service provider. They need to give you some sort of assurance that that data is gone. What a lot of places will use is a certificate of destruction. So you, as the client, can generally prescribe a method if they haven't done something. So you can say you require a secure deletion of at least 5 passes, and they need to provide proof that they've done so. And there's a lot of software packages that they can use to do that, and they can issue you with a certificate. And then you've got some sort of legal ground as well if later it turns out that they haven't removed it. But you want to keep up with that and chase them. You are perfectly welcome to chase your suppliers. And under GDPR as well, one of the requirements that you have is that you need to audit your providers. So if you have DR as a service, you should go and audit that they are actually deleting the stuff, and you can do your own due diligence there. They need to comply with that. So let us move on to data privacy impact assessments. This is very much a GDPR requirement, but if the rumor mill is to be believed and the way we're looking at different data laws working across the world, they are going to be coming to South Africa. And if you are dealing with European companies, like we've said, you need to comply with their laws anyway, so you may as well look at them now. So a data privacy impact assessment looks at the impact that a new development, a new process, a new procedure, a new spec, a new feature, anything like that can have on privacy of individuals. So a DPIA is needed when you are using a new technology. So if you are moving stacks or something like that, you need to look at doing a DPIA and having it on record. It needs to be done when there are high risks against rights and freedoms of individuals. Now, this is an easy one to sort of brush by the wayside and say, oh, well, our function is not going to have any effect on like human rights and things like that. Bear in mind that the right to privacy is a right of the individual. So just by virtue of having a feature where data could be lost, that is a risk to rights and freedoms. So you need to look at that. And it is also required when you're doing any sort of automated processing, if you are processing things like criminal records or anything like that, or special categories of information. And a good way to look at special categories of information is it's any information where someone could be discriminated against. So things like sexuality, lifestyle, gender, your political views, things like that. So anywhere your race in South Africa with BEE submissions and things like that, anything like that is seen as a special category of information. So if you're doing that kind of processing, very much involved. That also applies to things like biometrics and CCTV. So bear that in mind as well. If you're doing some sort of visual recognition on recordings or anything like that in your software, you need to look at doing a DPIA. And it also is required if you're doing any sort of large scale, big data analysis, that kind of thing. Now, this is what the law says, is when the requirement is there. What I'm going to say to you is very clearly, do it anyway. If we are doing data privacy impact assessments as a checklist exercise as and when, it literally becomes a checklist exercise. People mark it off and pass it away without actually paying enough attention to it. If it is part of your ethical responsibility to do in your SDLC on every feature, it becomes a lot easier to implement across the business. It takes perhaps a little longer because every spec does it, but it makes life so much easier. Now, what should a DPIA contain? Because if you look this up online, I tell you what, you will see that you need to do a 17-page DPIA, or you need to do a 34-page DPIA. No, you need to do what is required and what should be in a DPIA. So it's very important to ask the right questions, not just ask all the questions. You want to have a description of what your processing is going to be, what the purpose of that processing is, what your interest is in processing that. Do you have a legitimate business interest in doing this? Do you have consent of the person to do this? Or do you have a contractual obligation? What is the interest that you have in doing this? Legitimate interest is a reason on its own where you are proving as a business that you need to do this. You need to look at the necessity of the processing, the risks to rights and freedoms, as we've said, and then your measures that you're putting in place. This could be something as simple as updating privacy policies. It could be something as complex as implementing a new set of firewalls and different, intrusion detection systems and all sorts of things like that. So you need to do that analysis for each of these features, but the point is that you have to do them. So my recommendations around DPIAs for software companies, shorten to the point, guys. We battle to get developers to put comments in code. Do you really expect someone to fill in 17 to 34 pages of an assessment when they do the spec? Please rather just keep it short and to the point, a little two-pager that covers those points, maybe a couple of other ones specific to your business, will go a whole long way in doing your DPIAs. Keep them on record as well. So if you're using Confluence or SharePoint or something like that, every time you do one, keep it on record. You should be doing this with your specs already, so just keep it with your specs. Every feature should have this. And then lastly, incorporate this into the SDLC. You want it to be a business as usual kind of thing, because then you're really sorted down the line. So keep that in there. Right, let's see if there's any questions so far. From a mapping data flow perspective, would you say it's important to map how the people, processes, and tech interact with your organization? Is a process-only mindset part of the problem? Yes, I would say so. Connor, thank you for that. Again, I want to try and get folks away from this command and control compliance kind of thing. And we're seeing very slowly the legal fraternity at least going this way too, is privacy compliance needs to move out of the compliance department. Privacy compliance is across the entire business. It's your developers, it's your receptionist, it is your C-suite, it is your BAs, it is your support consultants. Everyone needs to be involved with this. And data is created and passed around at different points. Verbal data is still data. QR codes are still data. This kind of stuff needs to be brought in. You need to have people being aware as well. One of the biggest things I do is I do company training, because everyone from reception, who is the front line of defense for the business in actual fact, right the way through to the C-suite, need to know what they're doing around this. And people create data. We create data by talking to each other. So yes, it has to be across the organization. It has to be across processes. It has to be across systems. We have automated systems that create data in other systems, logging. it's across the board, folks. So yeah, I think when you do your data flows, when you do your processes, so I think that's also why I say rather do an operating procedure than a process, because then you're discussing your purpose, you're discussing your scope, you're discussing the people involved, things like that. Try and do it that way. You definitely want to involve more than just a process diagram. Cool. Thank you, Connor. Right. No other questions so far. So let us jump into the next one, which is data de-identification and the risks thereof. Dun, dun, dun. This is where people jump in and say, this is our silver bullet. Data de-identification, anonymization is not a silver bullet, folks. It is a nail in the coffin. You want to be very, very careful if you're going along these routes. If you say to regulators or to people that you are doing anonymization, it has to be complete. It has to be completely irreversible. And that is where people fall short. They say, oh, it's anonymized. This database has got no information. We've serialized the names and blah, blah, blah. It can't be reversed. But then you can match it to another piece of data and suddenly you identify everyone again. Boom, fine from the regulator. If you do anonymization, it is one way. You cannot get it back. And if the regulator and their investigation finds out that you can get it back, you're in a world of hurt if you've said you've used anonymization. So be very, very, very careful there. What there is available, and I'm going to try and get this right, and if you want to have fun with any privacy professional, get them to say this word. Pseudonymization, yes, is a safer option. So what pseudonymization is where you, if you are sharing data, you share an anonymized data set where you keep basically the primary keys to re-identify it. You're not claiming this is anonymous. You are claiming that you are giving them data that's been pseudonymized. It puts you in a much better legal standing. So you can re-identify the data from this. You are not making false claims. It's a lot better for you to say that this is what you're doing and we're handing you anonymized data which can come back than saying it's anonymous and then someone gets it back anyway and then you're in a world of hurt. The downside to both of these situations is it is incredibly difficult on large data sets. To give you a really oversimplified view as well, if you have a data set, say a section of LinkedIn that you are going to hand to someone and you want to anonymize it, pseudonymize it, and give it out. But you've decided, okay, the way we're going to do that is we're going to remove the names and surnames. We're going to remove company names, blah, 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 blah. But there's maybe someone's left a domain and an email address somewhere so you can identify the company. And there is perhaps a job title. Now, together, those don't seem like big deals, but if there is only one CTO for a company and you've got the domain name for that company, you can really easily trace it back and de-identify it. So if that's just a small example, think of what it can be at scale with all these kind of identifiers that you can get for a company, be it phone numbers or addresses, things like that. You've got to be quite careful. Even in your classes and things like that, if you've got your domain name in that class, like contoso, whatever, JavaScript or anything, that's an identifier for a company. So just be careful of that. So recommendations on these ones. If you're going to do it, choose very wisely what you are going to do, because it can land you in hot water. Don't ever claim anonymity if you cannot absolutely, irrefutably not reverse that. So you want to make sure that if it's anonymous, there is no way it's being reversed, because otherwise you're in a lot of trouble. If you are going to share data with third parties, you can use pseudonymization, and it's a really good way of doing it. However, something that can be a better approach sometimes is to spend a lot more effort protecting the non-anonymous data. You know, there are methods that you can use that aren't as dangerous to you, where you are just putting additional controls and protections in place, as opposed to trying to do something that could land you in hotter water later. It's like out of the frying pan into the fire. So take a look at that when you're doing it. You want to focus on your protections. Right, let us move on to the difficulties of blanket risk assessments. I'd love to see a show of hands here in the window or anything, if you guys have had these wonderful experiences where clients hand you a assessment that covers practically every law across the world and every security process and all of this, and it's a 70-page spreadsheet that you have to do. Anyone feel that pain? I'm getting the odd little, yeah, there we go. Yes. So we get these blanket assessments, and it, oh man, it drives me insane when I have to respond to these because it's 70 pages of mostly drivel. But why do we have these blanket risk assessments? Well, the first real thing is the risk managers that these come from often have no clue. And when I say no clue here, I don't mean anything against the risk managers. That's the background I come from. What I mean is they are not tech specialists. So they don't know what goes into an infrastructure, an architecture, anything like that. I see a response here all the time. Thank you. Yes. So they're not clued up on the tech side of things. They're also not attorneys. They are there to manage the company's risk. So we've got to cut them a little bit of slack. You know, we often will take on the person handing this to us because it doesn't apply, but it's not their speciality to know that. They are being informed by someone else or being misinformed by someone else as well. It also comes from hyper-paranoia from companies. You have these global companies that you work with, or the banks, where they are regulated so tightly that if something goes wrong, they're in such a world of hurt that they try and cover every base they possibly can, sometimes to absolutely ridiculous levels. And the last big one that I see from a risk manager side is that, you know, the assumption is that everything is cloud-based, and this drives me insane because you will have software that you have to implement on a client's premises. It's on their infrastructure, it's on their systems, it's in their server rooms, but they will insist that a software company fills out a cloud form and gets SOC 2 reports from their own data centers for data that's not sitting in that data center. So it becomes really, really ridiculous. And I've got a remarkably simple resolution for that we'll get to in a moment. Another thing, and this is why I said the last one was for the risk manager side. The next thing that is a challenge on a blanket assessment is that a lot of people assume that technical standards is compliance with privacy. It is not the case. Technical standards does not equal compliance to privacy. And the biggest culprit here is ISO 27001. The fact that there is a 27701 means that 27001 is not compliance to privacy. But you know, we see this all the time where someone, no, we are NIST compliant, therefore we're privacy compliant. No, you're not. Like we mentioned earlier, it is across the business. It's not just your secure environment. It is the people in the business. It's training. It's much broader. So to assume that compliance to these standards means that you're compliant with an assessment is a big fault on the risk manager's side and on the company sending this to you side. Having said this, the common mistakes on companies that are software companies is that technical standards do not equal compliance. So guys, what I've just said applies to software companies as well. We assume often that ISO standards make us compliant. It doesn't. If you look at the way PwC looks at privacy, and also Bureau Veritas, who have a technical standard for privacy, the Bureau Veritas view is that an ISO 27001 covers 1/8 of their pillars that they have for privacy compliance. So yes, you can write off the technical component of your privacy compliant with ISO 27001. You're not writing off the policy component. You're not writing off the accountability component. You're not writing off the training components. So it really only covers one portion of it. So be very, very careful of that. Another big mistake that software company makes is they complete these risk assessments while being aspirational. If you don't have something in place, do not say you've got it in place. If you are, oh, we don't have that now, but we'll have it in a month's time when the deal is closed, don't put it in, please, because you don't want to have the wrong things on there if they do decide to audit you. And we do fill these things in aspirationally. No, well, we don't have someone who's got their CISSP now, but they should have written their exams by the time this goes through, therefore we'll say we've got someone with CISSP. No, please don't do that. It's a very dangerous precedent to be setting for yourself, and you can land yourself in massive hot water with that. That ties in with the next one, which is exaggerating your security position. There's a misconception where people say, you know what, we're going to fill this stuff in. No one's ever audited us before, and they're not going to. I tell you what, this year has been the year for audits, and I've had audits at most of my clients all of a sudden out of the blue, where people want the written documentation from a third party and they're willing to pay for it, that we're going to audit you within the next 30 days. You must see the scrambles that some folks are doing, and I'm getting phoned up by these guys saying, hey, don't you want to come in and help us with this stuff? And it's not a 30-day exercise. So you don't want to end up in the position where you've exaggerated your security position. And that ties into the next point and what I've discussed already. Don't assume you won't be asked for evidence. You very often will be asked for evidence, and I see it more and more frequently that evidence is being asked for. And I'm seeing people lose clients because they can't provide the evidence, and then the client is obliged to end the relationship. So be very careful of this stuff. You need to have this in place. So what are my recommendations for you? This is the very simple one for resolving a lot of these blanket assessments. Pick up the freaking phone. It is so easy to just pick up the phone, phone someone at the client, and just talk this through. Now, when I say phone someone at the client, don't speak to the project sponsor. It blows my mind as well when it comes to privacy, where the project sponsor is the one who signs off the data processing agreement and not the information officer. Chances are the person that's signing off your data processing agreement, if it's a project manager, project sponsor, head of whatever, chances are they don't actually have the authority to sign that document. So guys, you want to phone the client, you want to chat to the information officer or the data protection officer or the CISO or someone who is in the information space and chat to them about what's required. Often you will have them come back to you and say, oh, wait, you're in South Africa. Oh no, then don't worry about the CCPIA section. Don't worry about the GDPR section. Don't worry about POPIA section. Just fill in the part about your technical controls and we'll be done with it. You can save yourself a hell of a lot of time doing that. Then, when you do put security controls in place, please document your security controls. It is no good for you to put all these controls in place and you have them in place and then you get asked for evidence and you can't provide it. So you need to document these controls that you have in a shareable document. Now, that very much should be a separate document to your actual internal controls that are detailed level. You don't want to give away your security position by handing a document to a customer, but you want to give them enough assurance that you've got controls in place. Now, sometimes that's simpler than you think. I've seen it before with big companies where it's as simple as putting a letter together on a letterhead signed by the executive saying, yes, we comply. These are some of our controls. Boom, one pager, cool, we're done. So you want to have that conversation and see what will suffice for these things. It can save you a lot of trouble and you don't have to fill out 70 pages worth of spreadsheets. See there, one of the advantages of PCI. Yes, yes, it is. That's also a very big, I don't want to make it sound like I'm poo-pooing ISO 27001 when I spoke earlier. If you have ISO 27001 in place, if you have these technical standards in place, if you've got NIST in place, you have these things documented already. It is a great place to be to have these in place. What I just want to highlight is it doesn't cover the whole of privacy. But yeah, have this stuff in place. And then right up front, when you're doing these assessments, preferably before you even receive this assessment, clarify whether the solution is on premises or if it's cloud. Because you can sometimes absolutely lift any headaches just up front by saying, well, this is on premises. Oh, suddenly we don't have to give you these assessments. So get that up front before having to argue about it later. When you have hosting providers, keep a record of their certificates. So if you host at a, I don't know, well, Azure will have their SOC 2s and stuff available, but if you have a smaller host, say your Internet Solutions or something like that, get copies of their certifications for their data centers. It will save you a heap of trouble later when you have to respond to these risk assessments to already have these things in place. So get copies of that. Often they'll have them on their websites, or they will have a security center section of their website where they detail their controls instead. So take a look at that. The last recommendation I have on blanket assessments is hire someone with a security certificate in your business. Whether it's a CEH certificate, Certified Ethical Hacker, whether it's a CISSP, whether it's someone who's got their OSCP, get someone with some sort of cybersecurity certificate in your business, because often that is a mitigating factor as well. Because companies will give you these assessments, you can give a lot of peace of mind by saying, you know, we've actually got someone who is certified in this to respond. It's small, but it makes a whale of a difference on what you provide back to your clients when they give you these assessments. Having an issue with other execs wanting to give more on due diligence audits, yes. There's a tendency to try and prove that we're doing so much when it's not necessarily necessary. So we exaggerate our security position. The trouble is then that security position becomes the expected security position when you get an audit. So dangerous position to be in, and often you don't need to exaggerate on these things. Many times you will say, no, we don't have that in place, but it's not a deal breaker for the risk management team. It just ups a risk or a likelihood somewhere. You may have other mitigations in place. So yep, definitely happens. Folks, that was my whirlwind 50-minute take through some of the challenges that software execs and software companies can have in data privacy. Are there any other questions that you guys want to raise now? We can discuss them quickly now. If not, you've got my LinkedIn details up in front of you now. You can just scan the QR code and add me on LinkedIn. There's also a link to my newsletter there. And I'm very happy to field questions after this. If you guys have mulled it over a bit and want to take some of this on board and chew it over, you're welcome to email me at a later stage and give me some feedback there. One thing I wanted to ask, if anyone is interested, and you're welcome to email me for this, and I might just drop you an email as well, is I'm currently writing my second book, which is going to be on data privacy for software companies. And I'm looking for experiences that you've had or anything like that as a software company when it comes to privacy. What are your challenges? What are your wins? To try and inform this book that's going to go out to software companies. And the guys that do give me some of that information and help me with this, I'm very happy to give you 10 copies of the book when we get to October, when I expect to launch the book. So if you're keen on that, please drop me a line, and I'd love to have you on board with that. It can be anonymous or not. And then thank you very much for attending. I don't see any other questions here, but guys, thank you very much for attending. Like I said, you're welcome to email me. You can get me at hello@rossgsaunders.com with any of your questions. Also happy to set up a 15-minute call if you want to discuss anything further. Guys, thank you for joining. It's been great having you here. Hope to see you again for the next class that I host. Everyone keep well. Thank you very much.